All right, well, I'd like to welcome everyone today to our last Federalist Society event of the semester. And we'd just like to take a moment to thank you all who have come to our events in the past. And I think we've had a great semester. And looking forward to the exciting events we have next semester. So far, we have 7 speakers lined up on issues such as immigration, originalism in the Constitution. We also have a federal district court judge from Kentucky coming. So please stay tuned to the announcements we have about next semester's events, and we're really excited about it. I would also like to say a special thanks to the board members who have helped make all of the events that we've been putting on this semester possible. Without their hard work, getting food, setting up tables, and sending out, helping to publicize the events, we certainly would not have the quality of events that we have today. Now I'd like to introduce our topic for today. It's a continuation of an event that we had on Monday regarding the town of Greece versus Galloway, issue in which the town of Greece wanted to open their meetings up with prayer that was challenged by one of their citizens of the town, and it was argued in front of the Supreme Court last week. And so to talk about this case, I wanted to bring in a couple people who have a lot of ties to the law school and also a lot of experience dealing with this issue. First person is Tom Fisher, who is the Indiana Solicitor General and also an adjunct professor here at the law school. He has been the Indiana Solicitor General since 2005 and helped work on a legislative prayer case that Indiana dealt with that was ultimately resolved at the 7th Circuit Court of Appeals. He has also worked on an amicus brief that was filed with the U.S. Supreme Court on behalf of a variety of states. So he's very familiar with a lot of the legal issues and legislative prayer cases in general. After him, we'll have Professor Dan Conkle, who has also done a lot of work on Establishment Clause and the religion clauses in the Constitution. He's been a law professor here and doing constitutional law since 1983, and as one of his Con Law 2 students, learning a lot about these particular clauses at this time. So after Mr. Fisher and Professor Conkle get done speaking, we'll have time for questions, and I will have a break for people to leave at about 5 to 1. All right, with that, I'd like to introduce Mr. Fisher.
Thanks so much, Adam. I was just telling Professor Conkle beforehand that if this is what I have to do to get a lecture on the Establishment Clause from Dan Conkle, I will do it every time. I'm really looking forward to what you have to say about this more than anything. So, it's no secret, you don't really have to be as distinguished a scholar as Professor Conkle to know that the Establishment Clause doctrine is a complete mess. It's larded with grand-sounding multi-part tests and various other inquiries that the Supreme Court really ignores as often as it applies. The result tends to be a kind of sui generis set of inquiries for every conceivable context: prayers, displays, tax credits, tax exemptions, scholarship, ceremonies, rights of accommodation. There's very little doctrinal connection from one area to another. Sometimes there's a little history that's used. Sometimes it's a little endorsement that the court is concerned about. Every now and again, the court looks at whether there's coercion involved. And very remotely anymore, and only rarely in the most extreme circumstances, where the court asks whether there's any entanglement issue. That seems to be an issue that's on the way out. The court has had many opportunities to synthesize matters, but has lacked a majority favoring any particular direction. As Justice Scalia famously observed in his concurrence in the Lamb's Chapel case, the Lemon Test, the famous Lemon Test itself, is like some ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried. He has a way with words. Well, Town of Greece presents another opportunity for clarity. While it seems likely from my point of view that legislative prayer will remain viable after this case, I fear we will get more of the same muddled doctrine. Well, today I want to describe for you how the Attorney General of Indiana became involved in this dispute explain some of the key portions of our arguments, and then briefly recap the oral argument from last week. By way of background, for the Office of the Attorney General, our job in general is to defend government actions. Often this means defending statutes passed by the legislature, but occasionally it means defending practices and traditions of various parts of state government. And that's really the source of our involvement in Town of Greece. Indiana, like all 50 states in some form or fashion, has a tradition of legislative prayer. As I'm sure all of you, or at least many of you are familiar, in the Marsh v. Chambers case, the Supreme Court upheld the Nebraska unicameral's use of a paid chaplain to give a daily or a session prayer for each session day. And this was somebody that was hired and paid out of public funds. The court in Marsh said that legislative prayer was valid based on an unambiguous and unbroken history of more than 200 years, a history that made legislative prayer part of the fabric of our society. In particular, the court observed that the first Congress authorized the appointment of paid chaplains 3 days before it reached a final agreement on the language of the Bill of Rights. Concluded the Marsh court, clearly the men who wrote the First Amendment religion clause did not view paid legislative chaplains and opening prayers as a violation of that amendment, for the practice of opening sessions with prayer has continued without interruption ever since that early session of Congress. The court also warned against embarking on a sensitive evaluation or to, quote, parse the content of a particular prayer where there is no indication that the prayer opportunity has been exploited to proselytize or advance anyone or disparage any other faith or belief. Well, Marsh seemed to remove legislative prayer from the remaining wilderness of Establishment Clause doctrine, providing a clear constitutional license based on history and tradition, at least for this limited sector of the Establishment Clause. In recent years, however, lower courts have begun to dismiss Marsh's straightforward historical analysis and instead subject various prayer practices to the Endorsement Test, which is, of course, derived from Lemon, Lynch v. Donnelly, and County of Allegheny, late 80s case. Well, the Endorsement Test, in short, precludes government from undertaking any activity that has the purpose or effect of endorsing one religion over another or religion over non-religion. The Endorsement Test postdates Marsh. And lower courts have used it to override Marsh in some circumstances based on dictum from Allegheny, observing that the prayers at issue in Marsh did not have the effect of affiliating the government with any one specific faith or belief because the particular chaplain had removed all references to Christ from his prayers. The theory here is that so-called sectarian prayers have the effect of communicating government endorsement of religion. This use of Allegheny arose a few years ago in Indiana when a group of taxpayers challenged prayers in the Indiana House of Representatives in a case called Hinrichs versus Bosma. The Indiana House's practice is to rotate prayer givers every session day through the services of clergy nominated by representatives. So in contrast with Nebraska, where there was a paid chaplain, same chaplain every time, Indiana has a rotational system. The House, when it recruits or when it nominates prayer givers to provide that service, doesn't provide any really significant prayer guidance. It does issue a reminder that House members come from varying faiths and backgrounds, and it does suggest that the prayer givers strive for ecumenical prayers, but that is the extent of it. The Indiana House's rotation system has yielded many prayers over the years given expressly in the name of Jesus. There also have been prayers given by rabbis and a few imams, but the vast majority of these prayers have been overtly Christian. In the Hinrichs case, Maurer School of Law's own resident federal appeals judge, David Hamilton, and then this is being recorded, so I have to add, whom I greatly admire, who is a man worthy of tremendous respect, even though we disagree philosophically, and I do consider him a good friend. He was then district court judge, and he deemed, quote unquote, sectarian prayers to be illegal. Rejecting the Marsh historical analysis, the court instead applied the Endorsement Test, which, in its view, forbids expressly and consistently sectarian prayers that express the faith of a particular religion. When we pressed for clarification following that judgment, Judge Hamilton said that while prayers given in the name of Jesus were unlawfully sectarian, among other types of prayers, prayers in the name of Allah were not, at least not without more evidence of Islamic content. Well, the injunction really stung and really hurt the practices of the Indiana House. But alas, the denouement of the Hendricks case was not terribly exciting. It was decided by the Seventh Circuit, but in short, and there is a much longer story here that I will spare you, the Seventh Circuit threw out the case on Article III standing grounds, ruling that the taxpayers could not challenge the Indiana House prayer practice. So we never got to a final appellate judgment on the merits of the Hendricks case. But along the way, Judge Hamilton's decision prepared us in the Indiana Attorney General's office to formulate our thoughts and to be prepared to lead other states when the issue or similar issues arose again around the country. And when the issue came up to the surface in the Town of Greece case, we decided that we would participate. In our view, Judge Hamilton's attempt to distinguish one name of God from another demonstrated really the futility of policing these prayers too closely to distinguish sectarian from non-sectarian. And as I will describe in a little bit in more detail, that discussion of the sectarian significance of Allah has become relevant once again in the Town of Greece case. The prayer practices of the Town of Greece do parallel to some degree the practices of the Indiana House. The town council invites clergy from religious communities within the town on a rotating basis, working through a periodically updated list of religious organizations published by the Greece Chamber of Commerce. As a service to the town and its council, each prayer giver delivers an unpreviewed, uncensored invocation. Very similar to Indiana, the result has been that the vast majority of prayers have been overtly Christian, though along the way there have been a few Jewish, Baha'i, and even Wiccan prayers. Very similar to Judge Hamilton's ruling in Hendricks, the Second Circuit ruled that sectarian prayers violate the Establishment Clause. It held that the Establishment Clause is violated, quote, where the overwhelming predominance of prayers offered are associated, often in an explicitly sectarian way, with a particular creed, and where the town takes no steps to avoid the identification, but rather conveys the impression that the town officials themselves identify with the sectarian prayers. The court acknowledged, this is the Second Circuit I'm talking about, in the Town of Greece case, that the difficulties involved in scrubbing prayers to be free of unconstitutional religious affiliation would probably force municipalities to quote, pause and think carefully before adopting legislative prayer. Well, this approach was naturally disconcerting to those of us who have defended legislative prayer and who fear we may yet again one day be called upon to defend legislative prayer. So, acting in the role of amicus curiae, we wrote briefs at both the certiorari and merits stages supporting the Town of Greece, and we invited other states to join us. At the merit stage, we ended up with 23 states total, which, especially on something that is somewhat of a hot-button issue, is a pretty good assortment of states to have. To summarize our merits brief, the amici states urged the court to reaffirm the central holding of Marsh and to disclaim any role for the endorsement test when it comes to analyzing legislative prayer practices. We also urged the court to consider using this case as an opportunity to clarify Establishment Clause doctrine more generally by requiring a showing of religious coercion as a touchstone for proving any type of unlawful religious establishment. A few of our points are worth an in-depth discussion. First, in our view, enforcing an endorsement test and a quote-unquote non-sectarian mandate is utterly unworkable and indeed calls to mind government-sanctioned censorship of religious expression. For example, one circuit to review a legislative prayer practice or a local government prayer practice approved that city council's exclusion of a minister who wished to give a prayer in the name of Jesus Christ. In our view, it is an insult to individual expression and religious exercise to permit prayers only by those who agree to pray in the government-ordered fashion. The ability of a community's clergy to offer an invocation opening a legislative session is an honor that many would desire. But an endorsement test requiring officials to scrub prayers of particular religious references would exclude mention of specific deities or beliefs in their prayers, and that would effectively exclude many clergy wishing to offer their prayers. In this way, furthermore, the endorsement test is essentially self-defeating. A mandate for non-sectarian prayers, in effect, endorses a mode of belief. What a court decides is non-sectarian may very well be sectarian from a different perspective. Any religious reference, no matter how banal it may appear, carries with it religious connotations not agreed upon by all. In short, a court is not equipped to determine what individual believers find to be sectarian, and a judicial attempt to establish a non-sectarian norm risks creating a civil religion all its own. Indiana's experience in Hendricks illustrates the difficulties inherent in applying the endorsement test to legislative prayer. In attempting to rid the Indiana House of sectarian prayers, the court in effect banned overtly Christian prayers. And while the court acknowledged that a practice of sectarian prayer favoring any particular religion violates the Establishment Clause, including, the court said, sectarian Jewish or Muslim prayers, applying that injunction to preclude overt prayer references to Allah or Vishnu or Krishna, or other deities, would only have underscored government endorsement of what remained permissible, general references to God or no references to any deity at all. In this circumstance, where the religious reference occurs in the context of real-time religious exercise, and not simply as a part of a static civic symbol such as a seal or a motto, the enforced preference for a particular religious exercise would be unmistakable. The only practical solutions, therefore, are either to shut down legislative prayer altogether or to embrace the plurality of faiths in America that wish to step forward and offer legislative prayer. Accordingly, we next argued in our brief that there is substantial room in Establishment Clause doctrine for the latter proposition, that is, the idea of, through a rotational system, allowing multiple beliefs to come forward and offer prayers in the idiom of the speaker. Well, let's go back again briefly to Marsh. Without substantial discussion of the matter, the court in Marsh treated the prayer of a, quote, state-employed clergyman, close quote, as government speech. The circuits have in turn treated all legislative prayers as government speech, even when offered by a rotation of private citizens. The amici states urged the court to be skeptical of this doctrinal approach and to reject the assumption that the content of private citizens' prayers before legislative assemblies is attributable exclusively to the government. Such prayers, rather, are expressions of private belief made in service to an elected body of citizens. Those present may participate or not, but each citizen's mode of rendering this particular service to a governmental body may rightfully be accommodated. In terms of government-operated fora, let's bear in mind, the floor of a legislative body is perhaps sui generis. A legislative entity is not typically an open forum, where all may speak on any subject without fear of viewpoint or even content discrimination. It is not even a limited public forum, such as a university meeting hall or a city-owned theater, where government may restrict the topics, but not the individuals who speak or the viewpoints discussed. Rather, no one, other than perhaps an elected legislator, has a right to speak on the floor of an elected legislative body. In the American tradition, of course, each legislative assembly chooses officers who decide who may speak on which subjects at any given time. Protection of legislators' floor speech rights is largely a matter for speech and debate clauses, and of course for electoral accountability. In fact, the extent to which legislators have judicially enforceable First Amendment free speech rights on the chamber floor is far from clear. Regardless, statements made on the floor of an elected legislative body do not generally constitute speech by, quote, the government. In a very real sense, even legislators retain their identities as individual citizens when they speak in support of a bill or resolution, regardless that they do so officially as elected representatives. Citizen speech in that context is even more removed from official sponsorship. It occurs only if invited, to be sure, but it does in no way constitute speech of the body itself. A legislative body in a republic has this particular functional need, that is, both to invite citizen speech by elected representatives and others, and to restrict who speaks on which topics. So while invited prayer fulfills a legislative function generally in the American tradition, the specific words of each prayer belong to the speaker and those who wish to participate. The Establishment Clause generally permits government accommodation of individual religious practices, especially amid legitimate service to the government. Religious accommodation in general is a venerable American norm. It was formerly the baseline standard of the Free Exercise Clause doctrine. And even now, it extends to contexts where religious leaders use their faiths and expertise to render government service, such as through prison and military chaplaincy programs. The long-standing tradition of legislative prayer fits this model, particularly when carried out through private citizens and the voices of private clergy. Citizens offer prayers in service to an elected assembly, and in so doing may receive accommodation of their individual beliefs without implicating the Establishment Clause. Sanitizing legislative prayers of sectarian references, on the other hand, deprives adherents of the chance to undertake religious exercise based on core beliefs, to the point where some otherwise willing citizens may forego offering legislative prayer entirely if they cannot do so according to their consciences. In short, in our view, the history of legislative prayer, the traditional and structural necessity of legislative floor control, and the American culture of religious accommodation combine to create a system where legislative assemblies may, without even remotely threatening an establishment of religion, invite citizens to offer uncensored prayers at the beginning of each legislative session day. Now, as you know, the court heard oral argument on this matter last week, and most assume that the court will break along its traditional left-right lines, with Justice Kennedy providing the deciding vote. My sense from listening to the oral argument is largely the same. Some think that Justice Breyer's vote is in play, and he did have some skeptical questions of the respondents' lawyers, and he did provide the swing vote in the Ten Commandments cases, voting yes for Texas in one case, but against McCreary County's display in another case. I have to tell you, I've learned the hard way not to bank on Justice Breyer's vote. He has a tendency to ask many questions of both sides that would suggest leanings that simply, at the end of the day, are not there, especially in a close case where he doesn't have an opportunity to split the baby, as it were, as he did in the Ten Commandments case. I worry that ultimately he will stay with his more liberal colleagues. As for the argument itself, it was quite an interesting discussion to follow. Former Kennedy clerk and esteemed Supreme Court advocate Thomas Hungar argued for the town of Greece in defense of the legislative prayer. The justices, including Justice Kennedy, explored with him whether there are any limits to relying on history as a justification for public religious exercise. Indeed, the only really troubling moment of the argument for Hungar came when Justice Kennedy said, "Well, the essence of the argument is we've always done it this way, which has some force to it, but it seems to me your argument begins and ends there." And there was an obvious sense of skepticism from Justice Kennedy in asking this question about whether that was really enough to support overtly Christian prayers when they would predominate in a local community setting. So the implication might be that Kennedy is at least somewhat troubled by seemingly arbitrary historical aberrations, as he called them, among various government practices at the founding. Mr. Hungar's response was that his position has just as much to do with lack of coercion as with history, trying to appeal to Justice Kennedy's often salutary views of the coercion doctrine in past cases. Perhaps that will be enough to assuage Justice Kennedy's concern, but of course we don't really know. Deputy United States Solicitor General Ian Gershengorn, who argued in support of the town of Greece as well, focused on the difficulty of administering a rule precluding so-called sectarian prayers. Question by Justice Sotomayor about whether one really needed to, quote unquote, parse the prayers, which again is a practice off limits under the Marsh Doctrine, whether one really needed to do that in order to determine whether the prayer was sectarian. Mr. Gershengorn pointed out that for some prayers there is substantial lack of agreement over whether they are devoted to one religious faith or, in the term of the day, sectarian. And this is where, interestingly enough, Indiana's experience with the Hendricks case came briefly into play. Mr. Gershengorn noted both that various parties and amici disagree about whether Holy Spirit is sectarian, but he also noted that, quote, a district court has held that Allah is not sectarian. There's only one district court I know of that actually ventured an opinion on that. Of course, we and the town of Greece, and as it happens, the United States, had mentioned the Allah issue in our briefs. But I was particularly gratified that Mr. Gershengorn worked it into his argument. We will see in a few months whether it influences any of the justices, but it's clearly on the table for them to consider. Professor Douglas Laycock, who argued for respondents, was pressed by the Chief Justice and Justices Alito and Scalia to identify, quote unquote, non-sectarian prayers acceptable to all religions. The best Professor Laycock could do is identify prayers to the Almighty and Heavenly Father, though he acknowledged that even these would exclude atheists and polytheists. Perhaps more troubling for his position, he acknowledged that town officials would have some responsibility for instructing prayer givers as to appropriate content of prayers and perhaps even editing them or refusing repeat appearances by those who supposedly crossed the line. Justice Kennedy noted that, quote, it seems to me that enforcing that standard involves the state very heavily in the censorship and the approval or disapproval of prayers. And he did not mean that in a good way. With respect to the accommodation argument I have described, Justice Scalia did spend some time asking about Professor Laycock about the significance of the fact that with legislative prayer, it is really citizens, not government officials, giving the prayer. He observed that there is a serious religious interest on the other side of this thing, and I'm quoting here, that people who have religious beliefs ought to be able to invoke the deity when they are acting as citizens and not as judges or as experts in the executive branch. Later he noted, quote, that's really part of the issue, whether they're undertaking a government function or whether they're acting as citizens in a legislative body, representatives of the people who bring their own personal beliefs. And that's why we separate legislative prayers from other kinds of prayers. I do hope that Justice Scalia sincerely views the issue this way. Finally, Justice Kagan, toward the end of Professor Laycock's presentation, made perhaps the most universally accepted point of the day when she noted that, quote, every time the court gets involved in things like this, it seems to make the problem worse rather than better. Again, one does not need to be as distinguished a scholar as Dan Conkle to see that this is largely true. But I fear Justice Kagan will use that observation to vote to curtail a long-established American legislative tradition, rather than to justify a rotational system of legislative prayers that takes all comers. We will find out before July. Thank you.
Thank you, Tom. I think that was really a wonderful sort of recap and presentation of the state's argument and really the case in general. And may I say further that we're really delighted, and I think it's wonderful to have someone as illustrious as Tom as an alumnus and an adjunct and really a highly accomplished practitioner. And if I can find my glasses, I will actually have something to say. I want to sort of talk relatively briefly and pick up some of the themes that I think came out of Tom's talk and put them in maybe a little bit of a broader context. Essentially, as I understand the state's position here, among other things, is we need a clear result, if possible, more clarity in the Supreme Court's Establishment Clause doctrine, which is in fact something of a morass, as Mr. Fisher indicated. And in this particular case, I think there are really only two more or less clear results. One would be the result that is being urged by the states, being urged by the town of Greece, being urged by the Solicitor General of the United States, which, by the way, was a somewhat surprising or at least interesting development, the Obama administration coming in on behalf of the town here in favor of permitting the prayers to go forward. The clear result in favor of the town, as urged by the various advocates on that side, including the state of Indiana, is in essence reaffirm Marsh versus Chambers, approve legislative prayer, with only two rather minimalist limitations. One would be that if you have a rotational system at least, and presumably, I'm not sure how you would enforce it, even if you have a paid chaplain, such as the state of Nebraska or the House and the Senate in the United States Congress, you cannot have sort of formally overt discrimination in favor of a particular religion. So in a rotational system, presumably, town of Greece would be in trouble if they had an official policy or you otherwise could prove that they only permit Christians to offer the prayers. That would be a problem. But if you have a formally neutral system, such as the town of Greece does, anyone can give a prayer if they want to, then you're okay in terms of the selection criteria. The second limitation, which I assume the states would be okay with, and I think certainly the Obama administration is okay with, is the limitation that was stated in Marsh itself, which indicated that the prayers that were offered could not be exploited, was the word the court used, exploited either to proselytize on behalf of a particular religion or to disparage another religion. Was in essence the court's basic language, which, as discussed in the town of Greece case itself by the Second Circuit, presumably is confined to prayers that are not merely sectarian in the sense of, for example, being Christian, but that would go beyond that, basically perhaps urging God to bring his wrath on non-Christians, some kind of prayer that indicates some kind of hostility to competing religious faiths, or that otherwise is sort of, I'm not sure how even that would be defined, a proselytizing prayer, praying to God, bring all of the citizens in this room to Christ and to salvation. Maybe that would be over the line. In any event, the Supreme Court, even in Marsh, suggested that some content would be improper, proselytizing, disparaging sorts of prayers. If the Obama administration, the town of Greece, and supported here by the states are successful, that limitation presumably would remain in place, but it presumably does not amount to much in that those sorts of prayers presumably would be few and far between, and in essence the judicial role would be put at a bare minimum as long as you don't formally discriminate in terms of the selection process, as long as you avoid those extreme prayers, you're okay. The other, and that would be a pretty clear result, and I think then you would sort of end most litigation, if not all litigation, over legislative prayer. The other possible clear result would be to overrule Marsh v. Chambers and say that all legislative prayer, even in Congress, should be declared unlawful. That would be a pretty clear result as well, albeit a result I think the Supreme Court is not likely to, in fact, reach in this case. What I'd like to suggest basically is that clear rules do have certain very strong advantages. Basically, clarity for lower courts, clarity for state and local governments, clarity for everybody in terms of what the law in fact ought to be. There's a strong jurisprudential principle that favors clarity over muddled results. At the same time, I think it's important to recognize that in a context such as this, the fact of the matter is that things are complicated here. In fact, you have multiple considerations that properly are relevant in this particular situation that would not, in fact, lead you to either of these clear results. And let me suggest that there are, and I think some of what Mr. Fisher was talking about sort of come into the various factors I want to talk about a little bit, but basically I think there are at least 4 variables that are at work not only in this case, but in other cases involving what might be described as religious expression in governmental settings. Religious expression in governmental settings would range from, for example, Ten Commandments Monument on the State House grounds, prayer by teachers in the public schools leading their kids in prayer, in God we trust, on our coinage as part of our national motto, one nation under God in the Pledge of Allegiance. A variety of settings are present, including legislative prayer, in which there is religious expression taking place in a governmental setting. The 4 variables, and I think they are variables, a continuum that moves from one end of the spectrum from perhaps to the other, include, number 1, tradition. And tradition, I think, is relevant. It's heavily relied upon here by everyone defending the prayers in this case. The tradition does go back all the way to the founding and before. It goes back to the first Congress, if and to the extent that tradition properly should inform the meaning of the First Amendment. That is a strong argument in favor of permitting legislative prayer to go forward. So if tradition is a variable, as I think it is, this case falls very strongly on the tradition side. History and tradition strongly supports the practice that is at issue here. Again, just to make the point that it is a variable, one nation under God in the Pledge of Allegiance. That has been defended likewise on the basis in part of tradition. It has a tradition as well. It's not as long. It goes back to 1954. There are other things that are highly traditional that have been declared invalid. Teacher-led prayer in the public schools. You might, in fact, find a rather deeply embedded tradition there. In any event, on a continuum with respect to something that is highly traditional on the one hand, highly novel on the other, this is highly traditional. And in fact, it has the added support of being approved by the first Congress, the same Congress that, in fact, adopted, or I should say recommended, the First Amendment itself. Second variable, in addition to tradition, is the variable of governmental coercion, or you might say aggressiveness on the part of the government as opposed to pure passivity. So again, on a spectrum in terms of direct coercion, it would be coercion in the Scalia sense, coercion enforced by law. So in the town of Greece case, the example would be, you're in the audience, and the prayer giver would announce, you say amen at the end of this prayer, or you're going to be locked up and thrown in jail. I mean, that would be sort of the old-fashioned classic case of extreme coercion, and maybe if you go back to traditional establishments back in pre-colonial times, or maybe even in colonial times in the United States, that might be the form of coercion that is at issue. On the other extreme, you have what the Supreme Court, or at least a plurality, has described as passive religious displays. Ten Commandments monument in a park. Okay, the government isn't coercing anybody in any obvious sense or in any meaningful sense. It is a passive, perhaps an endorsement of religion, but in a purely passive setting. And the question is there something in between? You have, in the public school context, even if children have a formal right to opt out, the Supreme Court has strongly suggested that there is peer pressure, social pressure to participate in the prayer, and that's a relevant factor. Conversely, or I should say sort of moving along the spectrum, you've got the town of Greece case. And the challengers of the prayer are suggesting that unlike in the Indiana legislature, where mainly only legislators are present when the prayer is taking place, likewise in Congress, town board meeting is different. The podium is facing the audience, just as this podium is facing the audience when the prayer giver gives the prayer, and at least some of the folks in the audience may be about to petition the town board, for example, for a change in zoning law. And the argument being made by the challengers is that is peer pressure or public pressure, sort of coercion, and you're probably going to bow your head rather than run the risk of ruffling the feathers of the town board that is about to vote on your petition. So that's sort of an argument of subtle, indirect, coercive pressure. So I think this case, to that extent, the town of Greece case, maybe more than the Indiana legislature case, does suggest at least a plausible argument of some degree of pressure to participate by bowing your head. For example, beyond that would be present clearly for a Ten Commandments monument, for example, sitting in a public park, but I don't think it's like teacher-led prayer in the public schools. It's not that coercive. These are mainly adults. Nor is it anything like sort of old-fashioned establishment back in colonial and earlier times where you actually have force of law for participation in religious practices. So to some extent, this case, I think, falls in the middle of the spectrum, maybe not terribly coercive, but maybe some degree of pressure here that might, in fact, be relevant. Third sort of variable is the specificity of the religious expression. And likewise here, you can think of one nation under God. Okay, two words, under God, very minimalist, albeit clearly theistic, clearly religious in any reasonable sense, but not much in the way of detail. Not specifically Christian, not sectarian in the language that the court would use. and certainly not, if you want to go to the extreme of the language in Marsh, not disparaging, not proselytizing. And in essence, there is a very strong stream of reasoning in the Supreme Court that in fact suggests, and I think this case is sort of pushing the issue, that generalized references to religion are acceptable to a degree that more specific so-called sectarian references are more problematic. And that's based in part on history. And that Justice Scalia, for example, has in the past been a strong promoter of this distinction, in essence suggesting that generalized theism is okay because that's supported by a long run of American history, whereas more specifically sectarian references on behalf of the government are more problematic. In essence, that it's one thing, as Justice Douglas once said, to say that we are a nation that in fact recognizes a supreme being as part of our heritage. It's something else to say that we are a Christian nation, and that is not consistent with the heritage that we have. Justice Scalia, notably, I think, and Doug Laycock, who was arguing against the prayer here, was sort of, I think, almost poking fun at Scalia without doing so directly. Basically, the question is, in part, can you come up with a proper definition of what counts as a permissibly non-sectarian promotion of religion? And Justice, or I should say Doug Laycock says, well, you've already provided it. Back to Justice Scalia. Scalia actually in the Ten Commandments cases wrote a rather elaborate brief suggesting that in fact the government was, and it's controversial, but nonetheless Scalia was saying the government is basically free to promote monotheism as a generalized expression consistent with American heritage, and that would in fact exclude atheists. And Scalia says it includes Christians, it includes Jews, it includes Muslims, and he has statistics, whether or not accurate, I don't know, basically saying that's 97% of professed believers in the United States, and basically that's good enough, and that that's consistent with the American heritage to permit that kind of generalized promotion of religion. Notably, in a case called Lee versus Wiseman, school graduation prayer case, where a majority 5-4 said that a rabbi could not give a conceitedly non-sectarian prayer when invited by the school to give a prayer at graduation, Scalia dissented. But Scalia said in the context of his dissent that it was a tradition of non-sectarian prayer that was deeply embedded in American society as opposed to sectarian prayer. And in fact, he had this to say, which I think, you know, he's clearly not going to adhere to in this case. I think it's pretty obvious. He said in the earlier case, I will concede that our constitutional tradition from the Declaration of Independence and the first inaugural address of Washington down to the present day has, with a few aberrations, ruled out of order government-sponsored endorsement of religion even when no coercion is present, where the endorsement is sectarian, in the sense of specifying details upon which men and women who believe in a benevolent, omnipotent creator and ruler of the world are known to differ, for example, the divinity of Christ. So basically, Scalia is saying there that it's one thing to have the government generally promote monotheism. It's something else to have the government promote Christianity in particular. Scalia, I think in the Ten Commandments case, said something, I think it was the Ten Commandments case, an oral argument said something like, you know, our coins say one nation under God, they don't say one nation under Jesus. You know, that's not our tradition. So in any event, I think the court, at least until this case, has in fact generally recognized across the spectrum of the justices that even if it's permissible to some extent, at least minimally, to have the government symbolically endorse or promote theism or monotheism or generalized references to God, it's at least more problematic if the government is engaging in more specific religious expression, promoting Christianity or any other religion in particular. Bringing me then to the fourth variable, which is something Mr. Fisher mentioned, which I think sort of is a counterpoint, and that is this really government expression? And you do have, as I think their brief very nicely, the brief very nicely laid out, this is a case that's mixed. You have In fact, in the Town of Greece case, legislative prayer generally, at least on a rotational system, it's harder to make the case, I think, that it's not governmental speech if you have a paid chaplain offering the prayer. But in any event, with a rotational system, I think there is a strong element of private as well as public expression, and to that extent, freedom of speech, freedom of religion come into play. And there is this issue about coercion. I shouldn't say coercion. There is this issue of censorship. Do you want Judge Hamilton? I like Judge Hamilton as well. Hi, Judge. If you're listening in, even if you have, you don't want a judge censoring, you don't want the government censoring this type of expression. And to the extent that it's private, that does sort of raise that issue in a way, for example, that is not raised by the Ten Commandments monument that is erected by the government and put on public property. That's pretty clearly, I think, exclusively governmental speech to the, at least all but exclusively governmental speech. So if you take all these variables together, I think it's plain that this is a really hard case if you want to have a subtle, nuanced, contextualized analysis. On the one hand, you have tradition strongly supporting continuation of the prayer. You have the private expression element suggesting the government should not be censoring the prayer. Conversely, you do have predominantly sectarian Christian prayer, which would seem to cut against the propriety of this type of practice, and you do have at least some element of coercion in the particular setting of the town board meeting, even if not in Congress and even if not in the Indiana legislature. So either clear result, I think, would in some sense be problematic. You overrule Marsh, you forget about tradition completely, you do avoid a lot of other problems if you go in that direction. If you don't overrule Marsh, you permit the prayer, you are avoiding the censorship, you're honoring the private aspect of the expression, you're honoring tradition, but at the same time you are permitting this preference for Christianity, a de facto preference in terms of the predominance of the prayer. You are pressuring, to some extent, citizens. You're at least excluding them in a way that in fact might not be fully inclusive, certainly of their interests, which might suggest maybe there should be some kind of a middle ground approach. A middle ground approach is plausible and is sensible in some respects. Some things, for example, suggested by Doug Laycock in his argument would be to try to sort of have some kind of a ruling that would minimize the coercion, the indirect coercion that might be present. For example, requiring some type of gap in time between the prayer on the one hand and any sort of citizen participation in a petition on the other. Maybe have some other type, I'm not sure exactly what it would mean, some other way of in fact minimizing the sense of coercive pressure might be supportive of some kind of a middle ground approach. Another sort of middle ground approach might be to require the government to do what the Indiana State House does, the House of Representatives, to at least request the prayer giver to be inclusive or ecumenical, which the town of Greece did not do. You could at least require that sort of a request to, in fact, perhaps at least encourage the prayer giver to be inclusive in what the prayer giver, in fact, has to say. Obviously, to the extent that you have some kind of a middle ground approach, you lose the clarity that is highly desirable and that certainly the state's brief is, in fact, urging. So, my bottom line here is I don't think the Supreme Court has a good result. I think that I agree with Justice Kagan to the extent that she says, maybe reading her differently than Mr. Fisher does, that the Supreme Court is likely to mess things up even more with its ruling. I think that's a highly probable possibility. If on the one hand you have some muddled middle ground approach, you get more litigation. The court theoretically could overrule Marsh. I just don't think that's going to happen, and if they did do that, that would basically be going directly at odds with what the first Congress, including James Madison, clearly contemplated to be unproblematic. So that would be a rather controversial constitutional ruling, to say the least. If the court approves the prayers, I don't think that's a terribly good result either, in that you are, in fact, permitting a practice that is predominantly Christian, that it is alienating to dissenting citizens, so that you end up, you avoid certain problems, but you create other problems or perpetuate other problems. So in some sense here, my bottom line is that I'm curious to see what the Supreme Court will do. I suspect that the prayers will be permitted to continue. In others, I think Mr. Fisher's argument is probably going to prevail here. I could be wrong about that, but I don't think that result is necessarily going to be desirable at the end of the day, even though the opposite result conceivably could be even worse. Thank you.